For what purpose does the gentleman from Hawaii, Mr. K, seek recognition?
Mr. Speaker, pursuant to House Resolution 1256, I call up H.R. 263 and ask for its immediate consideration in the House.
The clerk will report the title of the bill.
Union Calendar number 334, H.R. 263, a bill to amend the Lacey Act amendments of 1981 to clarify provisions enacted by the Captive Wildlife Safety Act to further the conservation of certain wildlife species and for other purposes.
Pursuant to House Resolution 1256, the amendment in the nature of a substitute recommended by the Committee on the Natural Resources printed in the bill is adopted. The bill as amended is considered read. The bill as amended shall be debatable for 1 hour, equally divided and controlled by the chair and the ranking minority member of the Committee on Natural Resources or the respective designees. After 1 hour of debate, it shall be in order to consider the further amendment printed in Part A of House Report 117444, if offered by the member designated in the report, which shall be considered read, shall be separately debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, and shall not be subject to demand for division of the question. The gentleman from Hawaii, Mr. Case, and the gentleman from Arkansas, Mr. Westerman, each will control 30 minutes. The chair now recognizes the honorable gentleman from Hawaii, Mr. Case.
Thank you, Mr. Speaker. I ask unanimous consent that all members may have 5 legislative days in which to revise and extend their remarks and to insert extraneous material on H.R. 263.
Without objection.
Mr. Speaker, I yield myself such time as I may consume.
The gentleman from Hawaii, Mr. Case, is recognized.
Thank you, Mr. Speaker. The question that this bill addresses is whether the private, unregistered ownership and exploitation of big cats, meaning lions, tigers, leopards, jaguars, cougars, and hybrids of them, should continue considering significant and real animal welfare, public safety, and law enforcement safety concerns. H.R. 263, the Big Cat Public Safety Act, says no and would end the ownership of big cats as private pets and prohibit exhibitors from allowing public contact with big cats, including cubs. This bill is a culmination of over a decade of bipartisan effort. The Big Cat Public Safety Act, in one form or another, has been introduced by, co-sponsored by, and generally supported by Republicans and Democrats alike for well over a decade. Since the 112th Congress, big cats have garnered 933 bipartisan co-sponsors. It was initially introduced by 3 different Republicans over a number of Congresses, as well as the current Democratic sponsor. We've continued to refine the bill in the decade since its first introduction. We passed it by suspension last Congress, and I urge my colleagues on both sides of the aisle to support it again now. The Big Cat Public Safety Act is endorsed not only by numerous environmental, animal welfare, and other organizations, but by countless law enforcement agencies and associations, including the National Sheriff's Association, the Fraternal Order of Police, state-specific sheriff's associations, and individual law enforcement officers. We need to look no further than the compelling testimony from Sheriff Matt Lutz before our Natural Resources Committee to understand the broad concerns with the status quo. In 2011 specifically, more than 50 exotic animals, including 38 lions, tigers, and cougars, were released into the public from a private residence in Zanesville, Ohio, shutting down a highway and terrifying the neighbors. Sheriff Lutz led the law enforcement response to the crisis. He testified at our hearing this year that his department didn't have any inventory of how many animals there were, barely even knew that they were there to start with, and his officers weren't trained, obviously, to deal with big cats and other exotic animals released into a public setting en masse. Incredibly, no one was killed or seriously injured in Zanesville that day, but as Sheriff Lutz testified, and I quote, "The outcome could have been much worse if any single condition had been just slightly different, and it could be far worse the next time." Precisely because private ownership is unregulated and largely unknown, we don't know how many big cats are currently kept in private ownership in the U.S., but estimates are as high as 20,000. Privately owned big cats are often purchased or bred as cubs for photo ops, and as they grow larger, they are sold into the exotic pet trade or onto the black market for wildlife parts. Adult big cats in private ownership typically live in inhumane conditions that threaten public safety. Since 1990, around 300 dangerous incidents involving big cats have resulted in human injuries, mauling, and death. In many cases, the animals are shot and killed as first responders are not equipped for these situations. In 2003, Congress unanimously passed the Captive Wildlife Safety Act, which amended the Lacey Act to prohibit importing, exporting, buying, selling, transporting, receiving, or acquiring big cats across states and the U.S. border. But though state laws vary, there is no federal policy regarding the private possession or use of big cats, and one is critically needed. This bill narrowly focuses on privately owned animals. It includes exemptions for exhibitors with U.S. Department of Agriculture or USDA Class C licenses, and current owners are grandfathered in as long as they register with the U.S. Fish and Wildlife Service and abide by listed regulations. H.R. 263 will protect first responders and the public as well as the animals themselves. In addition to public safety concerns, the exotic cat trade fuels other criminal behavior that we in Congress should not be supporting. As just one example, the TV series Tiger King showed us that there is a dark and dangerous side to keeping lions, tigers, and other big cats in captivity. In fact, Joe Exotic from that series is in jail for violating the Lacey Act and the Endangered Species Act. Now, some opponents of this bill argue that we need to make changes to the bill to help small zoos stay in business. This bill would not affect small zoos. The reality is that most zoos, whether they are big or small, already have policies in place that reflect the Big Cat Public Safety Act standards. They are not going to be asked to do anything that they're not doing already. They don't allow public contact or cub petting, and they already keep cats at a safe distance away from the public. There are only a small few who still allow it, and they shouldn't. Now, we may hear claims from my colleague on the other side that this is a USDA, U.S. Department of Agriculture issue, not a U.S. Fish and Wildlife Service issue. The fact is that the USDA does not regulate private ownership of animals like big cats. The Fish and Wildlife Service has long been responsible for regulating big cats' interstate transport and commerce under the Lacey Act, and has the authority to regulate the possession and breeding of endangered species, including big cats. While the USDA provides basic requirements for preventing cruelty to exhibited animals, Fish and Wildlife Service is the one that must provide stringent standards to ensure that threatened and endangered species are managed to actively promote conservation regardless of whether the animals are exhibited to the public. The Big Cats Public Safety Act merely strengthens and expands an already existing framework under the Lacey Act. It is a common sense and, again, uniquely bipartisan solution to address public safety and animal abuse concerns. I commend my colleague from Illinois, Mr. Quigley, on his work on this bill, and I urge the members to vote yes. Thank you, and I reserve the balance of my time.
The gentleman from Hawaii reserves.